Good evening, one and all. We welcome you all to this virtual CPE meeting on case studies of Aditya State Resolution under IBC, organized by the Committee on Insolvency and Bankruptcy Code of ICAI. This is part of an important initiative of the committee to organize series of webcasts on case studies of successful resolution cases under the Insolvency and Bankruptcy Code. Friends, we have with us today Alok Saxena ji, who is the insolvency professional and resolution professional for this case. And we also have C.A. Dilip Jagan, who is also insolvency professional and will be a moderator for today's VCM. As we know, the case studies always help us to understand the entire insolvency resolution process, its complexities and underlying challenges in taking care of various issues. The discussion on case studies provide a good learning opportunities for the professionals and stakeholders at large. Since the inception of Code in December 2016, a total of 4376 CIRP has been commenced and the Code has rescued 348 corporate debtors till March 2021 through resolution plan. They owed 5.67 lakh crore to creditors. Under the Code, the creditors recovered 2.09 lakh crore. Realization by financial creditors in comparison to their claims is around 39%, and realization by financial creditors under resolution plan is in comparison to liquidation value is about 180%. So the resolution is better than the liquidation. 348 CIRP, which have yielded resolution plan till March 2021, took on average 406 days, excluded time by Adjudicating Authority for conclusion of processes from insolvency commencement date to the approval of resolutions plan by the Adjudicating Authority. As the Code is continuously evolving and looking at the various developments that are taking place under the Insolvency and Bankruptcy Code, the committee is soon bringing out easy to understand handbook on important topics under the IBC on the various subjects including moratorium, resolution plan, personal guarantor to corporate debtor, claims, do's and don'ts for IPs, corporate insolvency resolution process, liquidation process and voluntary liquidation process, and on pre-packaged insolvency resolution process. Besides organizing these kind of VCMs on case studies of successful resolution cases under the IBC, the committee is also bringing out IBC case law updates on regular basis, and the updates have been hosted on the committee page on ICAI website. The committee also organize regularly refresher course for preparation of IBBI limited insolvency examination for the benefit of members at large. Considering the importance of Code and the professional opportunities therein, the committee will soon be launching certificate course on the Insolvency and Bankruptcy Code 2016. I once again welcome all the members for this virtual CPE meeting today on the case study on Aditya States. With this, I would like to introduce today's speaker or the presenter of the case study, I would rather say, C.A. Alok Saxena. C.A. Alok Saxena is a fellow member of ICAI. He is practicing over 3 decades. He is qualified insolvency professional and has acted resolution professional for various listed and unlisted companies having aggregate exposure of more than 5,000 crore. Being an insolvency professional, he is well versed with Insolvency and Bankruptcy Code and has led several forensic audits under IBC 2016. He is well versed and specialized in income tax, Companies Act, law relating to NBFC, foreign investment, and FEMA 1999. With this brief introduction of Sri CA Alok Saxena ji, I now request CA Alok Saxena ji to please go ahead with the presentation.
Welcome everybody. I'm Alok Saxena here. I'm about to present this case of successful resolution of Aditya Estates Private Limited. Just give you a brief background. This is not a real estate company per se, where people have booked flats or bungalows. This is a case where this corporate debtor had only one asset, which was a huge bungalow in Luton's, Delhi, and where we worked and got a resolution of this CD. So, Aditya Estates Private Limited would appear to be a real estate company. As you know, there are a lot of complications in real estate resolutions. But this particular case resolved or revolved around only one huge colonial bungalow in Luton's, Delhi, very close to Supreme Court of India, having the address 3 Bhagwan Das Road, New Delhi 1. So, with this background, I'll share the slideshow and we can go through the case. This is a case study of Aditya Estates Private Limited. This is a resolution under the IBC. Now, commencement of the IBC of CIRP in case of Aditya Estates Private Limited. This was a case where ICICI Bank UK PLC, we call it ICICI Bank UK, had granted a term loan of USD 63 million to Assam Oil Corporation Limited UK. For us, we are referring it to AOCL. It was a group company of the CD Aditya Estates Private Limited, and that was granted in 2007. And where the CD, that is Aditya Estates Private Limited India, had given a guarantee to the said loan. So this was a case of foreign bank, ICICI Bank UK PLC, giving a loan to a foreign company outside India, that was Assam Oil Corporation Limited UK, and the said loan was backed by a corporate guarantee given by the CD, that is Aditya Estates Private Limited, along with mortgage of the property in India. So this was one of the unique cases where we have a foreign bank, we have a foreign company. So the foreign bank has given it to the foreign company, and the Indian company, that is the CD, Aditya Estate Private Limited, which is a group company of the foreign company Assam Oil Corporation Limited UK, had guaranteed the loan. Now there were a lot of complications because it was the first time this sort of arrangement was before the Honorable NCLT. It took considerable arguments and there was a lot of debate. Some of the best brains in the country have argued this case, and finally the principal bench of NCLT New Delhi held that this sort of guarantee given by the Indian CD, that is Aditya Estate Private Limited, was admittable. The ICICI Bank UK PLC is a financial creditor and the CRP can be admitted based on the guarantee given. So this was a brief background about the complexity of this case to start with, right from the admission order. Some of the best brains have argued this case on this issue only, whether a foreign bank gives a loan to a foreign company guaranteed by an Indian company, that is our CD, and that CD can be then admitted to CIR. The company petitions CP 974 for initiating CIRP of Aditya Estates Private Limited was filed by ICICI Bank UK PLC under Section 7 of the Code in 2018. Honorable NCLT Principal Bench admitted the petition and initiated CIRP white writ order dated 26 February 2019. After the admission, I was appointed as a resolution professional in this case, and I took over the corporate debtor on 27th of February 2019. Now, what was the complicated documentation involved in the loan transaction of the guarantee? I said this was one of the first cases. This also involved a lot of complicated documentation for the loan transaction and the guarantee by the CD. So let us look at some of the principal documents which were there. The admission order took into account all the complicated documents as under. There was a facility arrangement between Assam Oil Company Limited UK and ICICI Bank UK, granting loan of $63 million. ICICI Bank India was also in the picture in this case. It had granted a loan of only 24.95 crores to Duncan McNeil Power India Limited and took the guarantee of the CD along with the mortgage of the property. Now this is an added complication into this case. ICICI Bank UK PLC has lent money to Assam Oil Company UK, guaranteed by a CD. ICICI Bank India has also granted to another sister company, Duncan McNeil Power India Limited, and took a guarantee of the CD along with the mortgage of the property. ICICI Bank India, the CD, that is Aditya Estate, and Duncan McNeil entered into a debt asset swap agreement. ICICI Bank UK was not part of the DASA agreement, that is the debt asset swap agreement, but under the DASA agreement, an undertaking was given to ICICI Bank UK that immovable property of the CD shall not be sold, unless the liability of ICICI Bank UK PLC is squared off. So basically, there were 4 players in this documentation. There was ICICI Bank UK PLC, the guarantor, the ICICI Bank India, the Duncan McNeil who had taken loan from ICICI Bank India, and there was the CD, Aditya Estate, who had guaranteed the loan of Duncan McNeil and also guaranteed the loan of Assam Oil Company Limited UK. So we had 4 players in this tripartite agreement. Now, this made the documentation extremely complex, and I'm happy to tell you that the admission order has taken all these documentation into account, deliberated on each and every documentation, which is a very rare thing. It is a 74 pages detailed order, and it dissects all these documents, and it then concludes. The conclusion is that the CD is a financial creditor vis-a-vis ICICI Bank UK's loan granted to Assam Oil Company Limited. Now, what were the challenges to the CIRP admission order? The suspended director of the CD filed an appeal against the CIRP initiation order before the Honorable National Company Law Appellate Tribunal on following grounds. The ground number 1, ICICI Bank UK PLC was not financial creditor as per IBC, as it had not granted any loan to Aditya Estates Private Limited, the CD. The decision of the Honorable NCLAT is held that ICICI Bank UK PLC is financial creditor in view of the guarantee given by the CD, and guarantors are financial creditors. Second objection, ICICI Bank UK PLC is not a financial creditor, as there is no guarantee for the loan granted to AOCL Limited, and the undertaking is not the form of guarantee. I may just tell the listeners that ICICI Bank UK PLC under the DASA agreement got a guarantee, but the guarantee was not exactly the guarantee which are in India. The guarantee was in a form of an undertaking not to dispose of the property of the CD until the loan is paid. So whether this undertaking itself was a form of guarantee was also debated and challenged before the NCLAT. And what the court held was the undertaking was discussed thoroughly and held to be in the nature of guarantee in a loan. So these were two of the four challenges. The third challenge was ICICI Bank UK PLC is not a signatory to the DASA agreement and the undertaking has no validity. As I mentioned earlier, there were four players. Three people signed the DASA agreement, that is a debt asset swap agreement, and that was not signed by ICICI UK PLC. It just got an undertaking from them under the DASA agreement. So the ground was ICICI Bank UK PLC is not a signatory to the DASA agreement and the undertaking has no validity. Held that it is true that ICICI Bank UK PLC was not a signatory to the DASA agreement, but it was shown as a beneficiary to the DASA agreement and therefore a part of the DASA agreement. Fourth ground, CD, that is Aditya Estates, had already discharged entire liability of Duncan McNeil, for which the CD had given the guarantee and mortgaged the property. CD is still bound, held that CD is still bound by the guarantee in the form of undertaking given to ICICI Bank UK PLC and therefore liable for the foreign debt given by ICICI Bank UK PLC to AOCL UK. So these were the various challenges taken by the suspended director against the order of the admission order of Honorable NCLT, and this was the replies. The objections were turned down and the appeal was dismissed. So there was no occasion for any stay on the order of the Honorable NCLT, and further the CD suspended director also appealed to on 30th September 19 before the Honorable Supreme Court of India, but no relief of any kind was granted to the suspended director, and ultimately the appeal was dismissed. So these were the challenges to the CIRP admission order, and there was a lot of litigation. I will also say it is not there in the slides, but I can also mention there was a case filed against me as a resolution professional stating that he had not acted in accordance with the regulations and the law, and he had done a lot of violations, and one of them was he classified them as financial creditors when he was not supposed to classify them, and there were other allegations against me, but the Honorable NCLT Principal Bench had also turned down those allegations. There was also a case filed against me to the IBBI, and I'm happy to state that IBBI had also discharged me from all the allegations made. So this is not in the slide, but I am just mentioning it to you. Going ahead, when we started the IBC process and the CRP process, and we made a public announcement of initiation of CIRP on 1st March 2019. I think the order was uploaded on 1st March 19. Creditors had filed their claims, which was submitted to the Honorable NCLT, and CoC was constituted as tabulated below. ICICI Bank UK PLC became a financial creditor with 89.52%, ICICI Bank Limited with 3.38%. Now, ICICI Bank UK PLC Limited was, by virtue of the corporate guarantee, granted for the loan to Duncan McNeil. So there was some small portion pending, which was not paid, 3.38% for which they came in. There was Spirit Infra Project and Multi Ventures. They had 6.99%. They had given an ICD of this amount. This is a Z Limited Group company, and then there is Shelja Commercial, who had also given an ICD of 0.11. So we had four members of the CoC as admitted as financial creditors, with ICICI Bank itself holding more than 92%. Now, what were the assets of these CD? Aditya Estates Private Limited had one property located at 3 Bhagwan Das Road, New Delhi. There are no other assets and no income. The said property was under perpetual lease from Land and Development Office. One of the issues which was also agitated, which I must mention, was that the CD doesn't own the property. Because, as you know, there has been a case of Seven Hills Hospital in the Supreme Court, where it has been held that leased property is not the property of the CD and it cannot be dealt with in the IBC. The RP cannot deal with it. But then this particular property was under perpetual lease or permanent lease amounting to ownership from the Land and Development Office. Therefore, the resolution of CD was centered around the property and its value. The property was a 3.44 acre plot in Luton's New Delhi 1 with a colonial bungalow constructed during British times and having passed through the ownership of several Maharajas and business stalwarts and ultimately came to be owned by suspended director's family through the controlling interest in Aditya Estate. It's a very interesting case with an interesting bungalow. So I put up the photo of this bungalow to make this case little interesting, and you can see this bungalow. What a grand bungalow it is. It is a huge bungalow with having 20 rooms. Having 20 rooms and a huge frontage right on Bhagwan Das Road, and a very good garden and a lawn and servants' quarters. It had everything. It's an unbelievable property in New Delhi and the sinecure of eyes of many, many big people who were interested in the property, as we'll see ahead. So this was a bungalow to cherish. Till I was in charge of this company, I always loved going to this place to see this bungalow time and again. One of the most beautiful properties I have seen. Now, what were the valuation and the challenges? Valuers were appointed by the RP within the stipulated timeline, and the valuers arrived at the average liquidation value of 306.80 crores. That means this bungalow and the open space, which was on a perpetual lease from LNDO, was valued at 306.80 by the valuers. Two valuers whose average liquidation value was 306 crores. Both valuers have stated that buyer, auction purchaser is liable to pay LNDO transfer fees and conversion from leasehold to freehold. Once such payment is considered from buyer, auction purchaser, the value shall stand reduced by 50%. Accordingly, average liquidation value stood at 153.40. I'll explain a bit about this valuation. The value of perpetual use was 306.80, but it involved a conversion charges and alternatively a charge for conversion from leasehold to freehold. Both these charges amounted to 153.40, which was 50% of the charges of the value. What it means is that if I was to sell this, the buyer would have to not only pay me, would have to pay X price to the financial creditors, would also have to pay some substantial amount to the LNDO to get the transfer in the name of the new buyer, and therefore that cost is about 50%. Now, one point which may arise is, or it will be working on the minds of the all our listeners, is that ultimately we are transferring the shares of the CD. We are not transferring the land. So where is the question of any transfer price being paid? But I am transferring the company per se. No, the LNDO rules clearly provide that where the shareholding changed more than 50% from what the old owners held, that would amount to a change of user, and you are liable to pay 50% of the value to LNDO for transfer charges. Therefore, the valuation with the transfer in the hands of the buyer stood at 153.40. Without the transferred cost, it was at 306.80. Therefore, we had two valuations on the table, 306.8 and after payment of LNDO charges of 153. But another argument was made that once the transfer charges should be over and above the liquidation value. No, there is no possibility of handing over. There is a provision in the LNDO rules that any transfer without paying the transfer charges would be illegal, and therefore we have to necessarily factor in the transfer charges in case we were to deal with this property. Otherwise, we cannot deal with this property without paying the transfer charge. So therefore, the transfer price or the transfer charges were inbuilt into the value of 306.80 in case we were transferring the property, and that was about 50%. So this value was going to be one of the very debatable. This was going to be a very debatable point as we see ahead in the slides during the time of resolution. I'll just take a minute. Therefore, we have the EOI and the final list. So after we started the process and we published the Form G within the prescribed timelines, we had the following people who bid for this property. As I mentioned, this is one of the priceless property of Delhi. One of the priceless property of Delhi. Now, this is part of the resolution order. So I have no hesitation in sharing it because it's now in the public domain. Otherwise, it will be very difficult to share this confidential data. And since it appears in the final order, I can always share it. We had Adani Properties, we had Anil Rai Gupta, we had Dalmia Cement, we have Malvinder Singh, we have Narayan Murthy of Infosys, we have Panch Tattva Promoters, we have Pramod Agarwal, Veena Investment, and Wellspun Logistics. So we practically had a very good list of buyers who were interested in this property, and we had appointed Knight Frank India Private Limited as marketing our property or the CD's getting interest in the EOIs, and Knight Frank did a wonderful job in contacting as many people as possible who are high net worth individuals who could possibly be interested in the property. So with this list, we went in for due diligence, etc., and we finally got plans from only two of the persons who were in the initial EOI list. We got offers from serial number 1 and serial number 8, that is Veena Investments and Adani Properties. So Adani Properties Private Limited submitted the bid, and Veena Investment Private Limited submitted their resolution plans within the prescribed timelines. Now I'm just sharing the highlights of APPL's plan, that is Adani Properties Private Limited's plan. They initially offered 400 crores with a condition that LNDO charges along with other charges would be paid from the said 400 crores. Now, we were not interested in paying the LNDO charges. So, on request of the CoC to make the plan unconditional and remove the uncertainty of payment to LNDO and other agencies, APPL, that is Adani Property Private Limited, revised the offer from 400 crores to 265 crores, giving a net reduction of 135 crores. The third feature was all amount was to be paid upfront. That means Adani was to pay 265 crores upfront for getting this property, and the LNDO charges would be paid by them extra whenever, whatever happened to that, and whenever they had to pay. We were not bothered about it. So we were insulated from the LNDO payment and other charges, and they gave us a net reduction of 135 crores. Now, let us see what Veena Investment had offered. Veena offered 225 crores, and in that with a condition that LNDO charges and other charges would be paid off from the 225 crores, or it would be waived and not levied on the RA, and in case the said charges are not waived, the plan would stand withdrawn. So what they were trying to say was, they will pay us 225 crores, of which either we pay the LNDO charges of from the 225 crores, or these LNDO charges we have to get it waived from the authorities, and in case if they are levied on the RA and these charges are not waived, the plan would stand withdrawn. So these were very onerous conditions that we'll see how the CoC has dealt with both these plans in the next slide. Now, what was the CoC decision on the plan? In case of Veena's plan, the CoC decided that the resolution plan was non-compliant, conditional and uncertain, and was not considered any further and was not to be put up for voting. Now, this condition that we have to pay the LNDO charges or have to get the waiver of the LNDO charges were very onerous condition, and we found out that we cannot get those conditions and it was unacceptable. This made the amount of 225 very uncertain, and this plan was not compliant. And condition, as all the listeners are aware, a conditional plan and an uncertain plan for the amount is not an acceptable plan. These are not non-compliant plans and could not be considered further. In case of Adani's plan, the CoC took an independent assessment from reputed advisors on the reduction of 135 crores, and they were independently estimated to cost around 140 crores, and therefore the reduction of 400 crores from 400 crores including LNDO charges to 265 crores excluding LNDO charges was found to be fair. So we had done our own study as to whether the reduction of 135 crores is justified or not. In fact, Adani gave us an estimate of 177 crores. He said, no, they were actually 177 crores, but we are still being conservative and ready to give you, we are trying to be liberal and giving you 135 crores. In fact, we should be reducing it by 177 crores. But we did an independent study, and from an independent estimate, we could get a cost that yes, it will cost 140 crores for the transfer. See, LNDO in Delhi and collectors in Mumbai both have a formula for charging their transfer fees. And that generally is based on the stamp duty value, and they charge nearly 33% in Mumbai or up to 50% in Delhi. So these are the standard charges of the LNDO transfer fee. So we had done a study ourselves, and we came to a conclusion to reputed advisor that the cost of transfer will be 140 crores, and therefore the reduction of 135 crores is justified and fair. So CoC evaluated Adani's plan in the context of reduction, and then after that found that the plan was compliant with Section 29A, and the affidavit was further verified by a specialized agency. The plan met with all the conditions of Section 32 of the regulation, and the same was found to be financially viable, and therefore this plan was put up for voting. And let us compare the approved plan with the liquidation value. Therefore, the approved plan, payment of as per approved plan was 265 crores, net of all charges. The valuation was 153 crores, 0.40 crores, net of all charges, excluding LNDO charges, and therefore the approved plan was much higher than the liquidation value. The recovery was around 44% of the claim of the financial creditors. FC's claim admitted claims of 593.55 crores. It may be noted that there was no OCs. So we were paying almost around 44% of the total claims. Now, what was the voting which was done in this case? This is also part of the order, so I have no problem in sharing it. ICICI Bank UK PLC voted for the plan. ICICI Bank Limited voted for the plan. Spirit voted against the plan. Shelja voted for the plan. The total voting was 100%, of which voted for the plan was 93.01 and voted against was 6.99%. That is 7% voted. And therefore the plan was declared to be approved. As you know, we need 66% for declaring the approved plan. We got more than 66, we got 93%. So this plan was declared as the successful and approved plan by the CoC. Now there were some challenges by Spirit, Infra Power and Multi Ventures Private Limited, who are the dissenting creditor. The dissenting creditor appeared before the adjudicating authority on the ground that the resolution plan of Adani Properties Private Limited, offering 265 crores, was below the liquidation value of 306.80 crores and argued that the same cannot be approved. The adjudicating authority discussed in detail the issue of valuation, and after taking into account the report of the valuers and the independent assessment held in para 52 of the order, that the net liquidation value excluding LNDO charges was 153.40 crores and the resolution plan offering 265 crores net of all LNDO charges and other charges was higher than the liquidation value. Therefore, the adjudicating authority or the NCLT principal bench went through the entire gamut of valuation, went through the entire plan. They saw through what was 306 crores, which was the valuation, and how LNDO charges were being factored in the valuation. And there is a lot of debate on this issue in the order, and ultimately in para 52, it upheld the stand of the CoC that the valuations would stand reduced by 50% to 153.40, and therefore the 265 crore offer net of LNDO is more than the liquidation value. While approving the resolution plan, the adjudicating authority relied upon the decision of the Honorable Supreme Court in the case of Maharashtra Seamless Limited versus Padmanabhan Venkatesh and others in civil appeal number 4242 of 2019, and held that the commercial wisdom of CoC shall prevail and cannot be interfered upon, and the resolution plans can also be lower than the liquidation value. People will recollect, listeners will recollect our resolution professionals will recollect, then Maharashtra Seamless Limited order is a benchmark order of the Honorable Supreme Court on the ground that the commercial wisdom of the CoC shall prevail, that is following SR Steel's order, and also on the ground that the resolutions need not be more than the liquidation value and they can be lower than the liquidation. Therefore, Maharashtra Seamless Limited order actually holds out and stands out on these 2 points. The adjudicating authority therefore rejected the contentions of the dissenting creditors and approved the resolution plan of Adani Properties Private Limited. No appeal was filed against the order of approval of the resolution plan, and therefore the resolution plan attained finality. So the CRP process was concluded within 270 days, which has been prescribed under the IBC. The Implementation and Monitoring Committee, short form IMC, was formed comprising of 5 members with resolution professional as the chairman for effective implementation of the plan. Accordingly, all payments were done and CD was handed over to Adani Properties Private Limited, being the successful resolution and bringing a successful resolution towards closure. So, let me just disclose that no confidential data has been shared in the presentation, and all data in the presentation is from the CRP admission order dated 26/2/19 and the resolution plan approval order dated 14/2/20 and public data available on IBBA website. So with this, we were able to hand over the CD to Adani Properties. The CIRP ended in 270 days. We got the final order in good time before the pandemic struck, and we could hand over this property before the pandemic struck, and therefore this resolution was successfully completed in a good time as far as this pandemic was concerned, and there was a lockdown and other issues with NCLT. Now I'll also explain to you that what was the role played by various agencies in this successful resolution. Because unless and until we discuss that, a discussion of CRP is not complete. I can first hand, I would say that the role of the legal team was very important. The legal team, we had absolutely the top legal advisors in this entire journey of CIRP, because there was basically a lot of legal challenges, and we needed a lot of study on the documentation. So we had the top lawyers assisting us in this resolution, and I think that was one very important point which stood out, that in case if we did not have a good legal team, I think this resolution would not have been possible. In fact, even the admission order has been, as I said, has been argued by some of the best legal brains in the country. For a very complicated documentation, the orders of 74 pages, very rare to see an admission order of 74 pages, and where all these documentations have been discussed threadbare, and it has been argued for days before the Honorable Principal Bench NCLT. So one important point player in this entire journey of CIRP from the admission till closure has been the role of the advocates and the legal team. The second, very important, was the role of the valuers. As we know, this entire resolution centered around the property at Lutyens, and the biggest of the biggest names were going to be associated for bidding for this property. So we had to take one of the best names, and the most important job in this entire CRP for the resolution professional was to get the correct value of this property because everything centered around the value. Let us take an example. Let us take a case. Supposing if the value was taken at 600 crores, somebody came to a value of 600 crores. I'll tell you why. Because the stamp duty value was not revised and it showed a very high amount. It showed a very, very high amount. Then you take another case where if somebody was to value it at a very, very high price, because it was earlier done many years back, this property was reportedly valued at 1,000 crores many years back. And supposing somebody was to value that, see, there is not too much of comparables in these values. Such type of property is not sold every day in Delhi. So it's very hard to get comparable valuations. See, comparable valuation is a good base, very good base for doing the valuation of the property. But where comparables are not available, the valuer are put to a big challenge as to how he can decide to the value. Therefore, comparable values not being available of similar type of properties in Lutyens, and then going from some track record which shows a very, very obnoxious value, the stamp duty value is again obnoxious, and then finding out the real value was really challenging for the value. So the second important component or the player or the person who has performed is the valuers. And the third important was the role of the CoC member. The CoC members were very proactive, which we don't see nowadays among the CoC members. The CoC members comprising ICICI Bank, UK PLC, ICICI Bank, India, Spirit and Stelja, they were really, really effective and they were very proactive in this entire CIRP. And we also worked as an RP. I also worked quite a bit into this, examining all these issues, and we were able to do justice to this case. Another aspect which has not been brought in this slide, which I would bring, since there were no operational creditors, this was not a running business, we did a PUFT study, that is for the preferential transactions, and there were some preferential transactions which have been reported in this case, not to the great extent, but yes, they have been reported. Now, these preferential application is still not disposed of in spite of the handing over of the CD to the new RA, that is Adani Properties, and it is still pending. So, these are the issues which are not on the slide, but I would like to bring it to your attention. Another last point which I would mention is that whenever litigation took place in this case, it is always directed towards the RP. It was always directed against the RPs, and it is usually that an RP has not done X thing or Y thing, or this he has done wrong, or this he has done right. So another learning in this case is that so long as we do our work effectively and to what is stated in the rules and law and regulations, we don't have to fear. And I've seen in this case that courts generally and in particular are supportive of RP's efforts, and that really didn't bother me much, even though all the cases were against me, so we could defend them quite appropriately. I have also to tell you that during this, when this case was going on, we got a lot of offers from, even after this deal EOI was issued, and there were a lot of players who could not participate and subsequently came to us. But we and some of the very important people, or well-known people, who said that they would now like to participate. But the CoC and the RP have kept the foot down and said that no, we cannot disrupt the process. And we succeeded in keeping a stand that even though you may be a very important person, you may be politically connected, or you may be X, Y, Z, it doesn't matter. Once the process is over, that point of time is over, we are not going to reverse those process. So there were some good learnings in this case as far as this as far as the role of the RP, the role of the CoC, the role of the legal advisors, the role of the valuers, and we brought this successful completion of this case. So I would be happy to share or learn, share some thoughts or any questions which you may have on this slides. And if there are any chats, if any speaker wants to raise any.
Dilip sir? Dilip sir? Yeah, you can put the questions received from the participants to the speaker, sir.
Thank you. Thank you, Alok ji, for taking us to the wonderful journey of resolution on a very hi-fi case. And definitely it is a power corridor if you can take the name of Luton's Bungalow. So it is a power corridor of India. So we thought that you make us walk through the corridor. So in thanks of complying with the IBC regulations and how you took us there and explained everything. But I must tell you, confidential. So you at the confidential Luton's Bungalow in public, beautiful bungalow. I'm taking it lightly. I'm taking it lightly for everybody, and sure we have received questions, and if you permit, I will take you to the questions.
Yes.
Questions to you, sir. Okay. First question is, can a leasehold property be considered as asset considering the explanation to section 18 since there was a leasehold property?
Yeah. Now, as far as this leasehold property is concerned, see, there is a case of Seven Hills Hospital which is decided by the Supreme Court of India in IBC. Which came much after our case has been resolved, but it said that leasehold property is not the property of the CD and should not be and cannot be dealt with by the RP. And if it is to be dealt with, then the consent of the leaseholder is required. So it has stated that it is not that a leasehold, see, Seven Hills Hospital is a hospital in Mumbai where the land is leased from the government of Maharashtra, and there is a huge hospital of 500 beds standing on it, which was under IBC under CIR. In that case, there were two findings given by the Honorable Supreme Court that per se leasehold land is not the property of the CD and should not be dealt with, and if it was going to be dealt with, it should the consent of the leaseholder and also his interest should be secured while dealing with the property of the lessee. It is not that in Seven Hills you cannot deal with the hospital unless you don't take the interest of the landowner into account. That is the government of Maharashtra or the BMC. So in that case, what had happened was that the CIRP was done without taking any payments which were due to the leaseholder into account or the interest of the leaseholder. So the Honorable Supreme Court said that this was not right and sent back the case again to the RP to consider along with the interest of the leaseholder. Now, yes, Dilip bhai?
No, please.
Yeah. So in our case, we are sitting on a perpetual lease agreement. This perpetual lease agreement of Luton's is more than 100 years old. That perpetual lease agreement says that we have this property is leased perpetually without any timeline given to you. Admittedly, all property in Lutens is leasehold property. So, and it's on perpetual lease. So we are dealing with a property in a different scenario where we are in a perpetual lease, we are holding perpetual lease, which amounts to ownership. This point was also argued before the NCLAT, and NCLAT said this almost amounts to ownership. And if you see the slides which we have presented, we have taken into account the transfer fees of LNDO. That is the interest of the LNDO. Therefore, we were, if you ask me, were truly complying with the order of the Honorable Supreme Court, even in case of Seven Hills Hospital, which came much later. But yes, we were complying with those orders. If I look in hindsight, that we were in fact complying with it, and we were taking care of the leasehold property and his rights, the owner's rights. Ultimately, he wants transfer fees. In case of Seven Hills, he wants his lease rent, renewed lease rent, and he wants whatever his charges are, which need to be taken into account in CRP. So per se, if you see all assets on which factories are built, whether it's MIDC land or GIDC land or Himachal Pradesh government land, these are all leasehold lands. So all lands on which factories are constructed under MIDCs or these or GIDCs are all leasehold lands. So it is not that you cannot deal with the property. You have to take into consideration the transfer charges and the interest of the owner. This is what I would say.
And I must support this your view with the another Supreme Court decision in the case of Mahara. And in that case also what you call the leasehold was what you call as there was no default and everything was proper, and Mahara was also a party to the tripartite agreement. Supreme Court rejected the taking back of the leasehold property by Mahara.
Yes.
Thank you, sir. Can I go with the second question?
Yes.
Second question is, as ICAI PLC was also involved in the lease, what do you call this transaction of financing, was for giving guarantee financing institution considered?
Can you repeat it? Your voice was breaking.
I am repeating the question.
Yeah.
I repeat again. UK PLC was the party to it, so and it is an overseas company. So was FEMA regulating overseas financial investor considered?
Yes, FEMA issues also was considered, and I'm happy to state that ultimately the remittance was made after getting all RBI permissions.
Okay, thank you. So it is compliant with FEMA?
Yes.
Thank you. Are becoming menace IBC and the banks are not in IBC. What's your comment on the same?
Dilip bhai, you need to repeat it again. I'm losing you.
As it is, the high haircuts are becoming a menace under IBC, contested to adopt the route of IBC. What's your comment on the same?
Yeah. What I understand from your question is there's a high haircuts in cases, and what do I feel about it? Am I right?
Correct.
So
Correct,
see, IBC is a law which first thing takes out the promoter. See, one of the biggest advantages for the bank is to get the money back, and what has been found is the money can come out, whether it is 1 rupee or 80 paise or 50 paise in a rupee only after you remove the promoter from the scene. Now that has been proved without doubt. If the promoter continues, you don't get even 1 paise. So therefore, I don't see IBC as a failure. I see that these are old cases, very legacy cases. So whatever you're recovering is, you're recovering what is due from the CD transparently and after removing the promoter, which is very important, and it is achieved only under IBC and not under any other law till now since independence. So I support IBC and because of this. Now, one of the reasons why the haircuts are too high, which is a matter of concern. Let us take Videocon's case, which is eye-opener, or Jet Airways case. What we find is that the claims also are getting high-pitched because of levy of huge interest and penal interest, etc. And those interests is for number of years. Means the NPA is happening in 2013, 2014. Old cases which are now, the interest is there for 10, 12 years and they are being loaded on the claims. The principal may be only 40% or 30%, but the interest components are becoming very large. There is no solution to it, but the haircuts look more because of the reason. So we have this interest part, we have a legacy issue, there is no real worth in the companies, and there is no asset basis in the company. So therefore, accepted that it is, haircuts are large, but we support IBC because it helps the bank recover the money, whatever it is.
Correct, sir. I am reading next question. Fourth, it is regarding challenges in the big challenge in CIRP is managing the affairs of the company as going concern. The challenge is even more if the company is large. How do you think a resolution professional can work out ways or methods in managing such affairs of the company?
Yes. Now, see, I agree with this question that IRP is a single individual who is having all the skill sets of IBC and he has to run the company as a going concern. Suddenly one day he has no board support. But one thing is there, these companies, large companies, have very good staff and very good responsible people who actually work with the RP and in ensuring that the company is a going concern. Therefore, in my other cases which are going on, I found that I have a lot of support from the managerial staff, the senior professionals, because they are interested in continuing their jobs. And for them, a revival is a good way that their jobs will continue.
Yes. Okay. Just, sir, I will support you and I will just add to something to this. I would like to put case of SR. Again, I had been an opportunity to hear what you call that particular, and at that particular point of time, resolution professionals said that SR in its lifetime of the production capacity. In the resolution process, what you call a CRP process, they were able to achieve 85% of the capacity. Again, it amounts to that challenges to be converted into opportunities by the resolution professionals, and they can maximize the value and they can do better things for the stakeholders.
Yes, I agree.
Thank you, sir. Now, I will proceed further. What strategies need to be undertaken by a resolution professional to maintain the going concern status? Now, how to continue the going concern status? What are the strategies?
See, one of the things which I have found from my past experiences that once the bank's finances are not available to you, so what you have to do is that you will only have the working capital which is available on the ground as on the date you take over. Whatever the debtors and whatever the stocks are there. See, you don't have to pay the creditors, old creditors, but new creditors you will have to pay. So you have to assess what is my working capital which is there when I start my business, and what is the reasonable turnover I will achieve. If it is sufficient to achieve, and that is where the planning comes with the managers, that you cannot start a business, you cannot think of expanding the business beyond what your reach is, your working capital permits. So if it's a manufacturing company, and if your working capital permits you only 35% capacity utilization, so be it. The making of profit or loss is not the concern of the RP. RP is required to maintain a going concern. Let us say if there is a nominal cash loss, because if there is a large cash loss, the unit will close going ahead. So we are not considering those situations. But if there is a small cash loss and it is sustainable for, let's say, 9 months, 10 months, and for that reason the unit can be kept going for 9 months or 270 days, 180 days or 270 days till resolution, I think that should be the strategy that should happen. So at least we can continue this going concern and preserve the value. See, closed unit, the value breaks. The value goes down drastically. So therefore, you have to work with the team, try to maintain the cash flow, try to be on a no profit, no loss basis. You are not going to get interim finance. Forget it. Interim finance is only on theory. You don't really get interim finance. It's a big struggle in to get resolution, professional fees from bankers if there is no cash flow. So you have to maintain, see that the unit runs with whatever working capital is there. Unfortunately, if the working capital is not there or it cannot happen, then you have no other option but to close it. You can't do anything. But my understanding is that if you can work out with the team based on whatever stock and debtors you have as on the date of taking over, and keep it going without trying to go beyond that limit. Let us say if 35% capacity can work easily, don't try to make it to 60 and 70%. Then you will face a collapse because you don't have support. So you can then achieve this a good going concern and maintain it. And if it runs, then you can pay all the charges and you can make this success story a success.
Thank you, sir. Next question, it is about selection of IRP and RP. What factors are important from a financial creditor's point of view at the time of selection of or approval of the IRP or RP? So what are the things they are looking into the IRP? Financial creditors are looking in IRP and RP for selection.
This is a question which should be answered by financial creditors, not by me. But still I will try to give you some. Say, IBC has slowed down a bit. So there are 2 or 3 things which are now we have to take into consideration as RPs. One thing is MSME limit of MSME definition has widened drastically, bringing into a lot of units under MSME. You know the definition now is very vast in terms of capital, 50 crores and 250 crores turnover. So very big definition of MSME. Now the limit for filing a case of MSME is 1 CR. So this practically puts all OCs out of MSME. MSMEs, no, there are very few OCs, means suppliers, who will give more than 1 CR to MSME. So there will not be any much OCs claim against MSME before the NCLT having 1 crore default. Financial creditors, yes, they will have a default of more than 1 crore. So that is one narrowing of the IBC as far as MSME. Then the other thing is this pandemic has slowed down the filing of cases and the admission of cases. So the selection of IRPs has also slowed down because not much cases are being filed. But I think this is a temporary phenomena. There is a lot of work for IRPs, and what FCs are looking at is, the FCs are today looking at a lower cost of fees. So that is a reality as on today, because of new cases not coming, that the fee structure has become very low. And that is one of the deciding points which financial creditors are taking into account. And of course, they do look at the competence of the RPs, but I think fees is a very big point which financial creditors are looking at. And I think rest of the things are quite even as far as capabilities are concerned with all RPs. So I don't think there's any big question on that.
Moratorium period, can banks file case on CD because court specifically halt any legal action against CD during moratorium? This is.
Can you repeat, Dilip Bhai, can you repeat the question?
I will repeat the question. Now, during the CIRP period, banks are filing case for declaring the promoters and other people as a defaulter, willful defaulter.
Yeah.
So
Yeah.
I think it pertains to that. During moratorium period, can banks file case on CD because court specifically halt any legal action against CD during moratorium?
Yes. See, as far as legal action is concerned against CDs, as far as legal action is concerned against promoters, against personal guarantors, can you hear me?
Yeah, I can hear you, sir.
Yes. Earlier there was a stay from the Honorable Supreme Court. Now with Lalit Kumar Jain's judgment having come, that you can file the case against the promoters simultaneously. The moratorium against the CD, it has been held against in the same judgment that a moratorium under Section 14 against the CD will not come in the way of the of any claim being filed by the promoter, by the financial creditors against the personal guarantees held by the financial creditors, and they can be proceeded with. All this has been discussed in the Lalit Kumar Jain's judgment.
I think if you can, yeah, and I think I will slightly twist, though it is not in the question, but I will slightly twist this question by putting that can operational creditor file a case against the company and promoter against Negotiable Instrument Act under Section 138?
No, 138. 138 has been found to be an action against when it is filed against the CD. Those proceedings are not to be proceeded with. Absolutely. Because that amounts to be action against the properties of the CD.
Absolutely.
So that has been held that it cannot be proceeded with. I think that Supreme Court has decided on this issue.
Yes, sir. Yes, sir. You are absolutely
now,
right.
As far as criminal liability of the director is concerned, there is no issue. Absolutely no issue. They can continue those proceedings.
Thank you, sir. Thank you. Now I am going further. More questions. What was the business of CD? Can you highlight the plan submitted by RA regarding the continuing the business of the CD? Otherwise, the RA appears to have submitted RP only the property.
Correct. So this was a very, very important question. Now, when we talk about going concern, we always talk about a running business. Now, in this case, the CD is having only a property, and that property is actually occupied by the director. That means the family which is occupied owning this property is also in occupation of the registered office of this company and is actually using it as a residence of this property. Now, one question kept coming to us, and this was also argued, that this is not a business of the CD. The CD doesn't have a business. But nowhere in the IBC it has been written that the CD should have a running business for it to be admitted into for CIR. There is nothing. What it says is whatever running business is there as on that day, that should be maintained by the RP. But it doesn't say that only those cases are to be admitted in CIRP are which having running businesses. So there is a distinction between that RP has to maintain the business as a going concern, yes. But to admit a case under CIRP, there is no requirement that there should be a running business per se.
Dilip ji, if you can put your video on, sir, if it is possible.
I think Saxena ji we have lost. I think he is not visible. I cannot hear his audio.
Can you hear me?
No, I can hear you, sir. Thank you.
Could you hear that answer?
Yeah, we have properly answered and say it is important thing that we have to keep the company alive. The company's business was to own the property.
Correct.
So that property and nothing else. So that property is transferred on account of approval of resolution plan.
Okay. That is true.
Correct. Now, one more question is saying how to save a company from going to liquidation. Now it implies that we are the Sanjeev. We have got Sanjeevani Booty with us.
See, we are the process runners, Dilip bhai and listeners. We are the process runners. We are not here to decide on the resolution plan. See, we are the facilitators, and we have to work in a manner given under the code, which is little. And if you are, I must say, if you be little proactive, it helps. Proactive means supposing there is you have a CD. If you try to seek buyers, now RP's job, if you ask me honestly, is not to seek buyers or resolution applicants. That is not the job of. If you read the code, nowhere it is written that RP has to go out and get buyers, get resolution interested party into this company. It is not written. It is said that he should run it as a going concern. But the RP can, and I think it is a responsibility to appoint some agency like we did in this case, Knight Frank. Because CD just, you cannot, these important people, who's and who of India, who are interested in this CD, they will not read the newspaper. The advertisement of Form G inviting UIs, it will not reach them. So we will need some agency to reach out to them. So we got 10 bids. We probably got after that another 10 people telling us that we are interested, and now we got to hear about it. So the reach of the RP should be such that he should have an agency with the permission of the CoC to reach out to them by being proactive. But ultimately we run the process, and depending upon how good we run the process, and that is what this will decide. And ultimately, if you get a bid on the CD and the CoC is the main player who have to vote, and they are the deciders whether this company will go in liquidation or whether it will go into resolution. And but we can assist in some manner or the other. That is all what it is.
Yeah. So I appreciate your effort. Thank you. I appreciate your effort that you have hired a marketing agency. Now many times I was listening to one FM channel, and it always says that jungle mein mor nacha kisne dekha. Then they say that you advertisement your business during this period and we will take care of everything. Now this is the practical example you have displayed that yes, we can do the things. Thank you, sir. Okay, I am going to next question. How do you take care of various compliances during the CIRP period?
Yes. How do you make compliances during CIRP period? See, now as IBBI has fairly standardized the compliances, and IIP also has fairly standardized the compliances. Earlier, during right up to 1920, there were a lot of changes. Now, of late, we have got only CIRP 7 having come into play. But by and large, we have been able to standardize the compliances. And so IBBI and IIPI compliances have got standardized. Now, as far as the ROC, income tax, FEMA compliances are concerned, now we always have professionals to do it for you. There are some challenges like uploading the CIRP order, asking the ROC to mark this as CIRP in the status of the corporate debtor in MCA, then taking hold of the GST compliances where you are the authorized signatory, then also becoming the compliance officers for income tax, so signatory. So there are some challenges, but I also say many a times we are giving directions to the old promoters to sign and execute those documents, to upload it. So we are also getting support from them, because that is also permissible, that we can ask them to do the compliance if we are not able to do it, and by giving suitable directions. So we are able to complete a compliance. And by and large, I think now things are getting streamlined in income tax, GST and MCA, which are the main compliances. So we should not face problems on all these fronts, and also on the IBBI and the IIPI compliance.
Now, can I proceed further? I am proceeding further. More question. While it is about claim, while admitting claims admitted based on what parameters? So on what parameters claims should be admitted?
Okay. Now, what parameters claim should be admitted is, see, claims is the heart of the IBC. So one should evaluate the claims. One should look at the books of accounts and the claim form and see that whatever has been filed is proper. And he should see that the claim figure, which includes interest, penal charges, penal interest, is properly worked out. Because as you know that there are couple of issues which revolves around claims, that what should be taken and what not should be taken. Like interest on penal interest is not to be taken. So we have to evaluate the financial creditors claim and the OC's claim along with the books of account. We have to keep the limitation issues, the period of limitation of 3 years, into account, and time barred claims which are not in the books of accounts in particular cannot be admitted, which are 3 years old. Supposing there's a claim of GST which is not in the books of accounts and we are not aware of it and we get to know about it, which is, so all these claims which come after 3 years, which are not in the books of accounts, should not be admitted. So we have to set up some checklist, and there is a handbook of check claims which is being brought by the institute, where I am also a party, which will help you in which will help all the RPs in finalizing and adjudicating the claims. Actually, we don't adjudicate, we only collate the claim and verify the claim. So we have this booklet coming from the institute, which will also help you with the claims.
Thank you. Next question. What are the ingredients necessary for a resolution plan?
For a good resolution plan, the ingredients mainly are that it should comply with IBC and all the 32 requirement. There is, if anybody is drafting a good plan, they should take the compliance list of regular section 32 and the regulations corresponding to that, and then see make a checklist that all those points are contained in the resolution plan. The first thing is he should do that. Second thing, he should use simple language and not use very complex language. It should be properly structured, where all the reliefs and concessions which you are trying to take from the government in particular or from the institutions, they should all be listed in one place rather than all over the plan. I have seen many plans where these reliefs and concessions are in different sections. No, they should all be in one part of the plan. So it's easy to understand. The financial plan should be very clearly spelled out. It should not be conditional. That is very important. There should not be any ifs and buts on the payment, because such conditional plans are not accepted by financial creditors. And there should be certainty of payment, that it will be paid within the timelines. So it should be very clear, and this is the bottom line of a plan. And we must see that we convey to the financial creditors everything in clear terms.
Okay, and it means important thing is that there are 5 sections in 2 sections and 3 regulations. They are very important. Section 30, submission of resolution plans, and 31, approval of resolution plan.
Yes.
And 3 regulations. Resolution plan, which provides you with 12 items. Basically, you can modify or you present your resolution plan. They are the methods, or you can say vehicle, which anybody can use. It contains of reduction of the credit pay, term loan, reduction in interest, or you can say deferment, or whatever you call concession you are asking. If you are thinking of changing in the constitution of the company, then yes, that you also can do. If you want to change the product mix, or you can say technology, again that also you can use. So all these are 12 things which is given in the regulation. They can do that thing. And what are the items that resolution plan should provide? That is given in regulation 38, and then 39 is the approval of the resolution plan.
Correct.
I think everything is briefly given by Alokji, and anybody, if you want to say the resolution plan, then they should concentrate these 5 sections. I am going to next paragraph. I think I am not clear on this question, but I am asking you, what happens if an RP is unable to execute his plan successfully despite given enough time? Will then the plan be aborted and his team fees withheld? I think it should be resolution applicant, because RP has not to give any resolution plan. He is facilitating the process.
Yeah. So I think what I understood from your question is that the RA has submitted a resolution plan, his plan has become successful, and then he is not able to implement the plan. Am I right?
Correct. That should be the question. I think because RP never submit any resolution plan.
Yeah. So in that case, there is a lot of issues. The regulation, the law is very clear that if he is not, the plan is binding on both. Firstly, one should understand that the plan is binding on all the parties. That is the RA and the financial creditors and the operational creditors and all other parties. So once it is made binding on all of you, then you cannot come out of that plan. So one of the biggest issue which is going on, and there are some issues going on now before the Supreme Court, although Supreme Court has already held that if, I think it is not Supreme Court in NCLAT, I need to just check up, is that a person who has submitted a plan even before approval, he cannot come out of it. A person, a resolution applicant who has submitted a resolution plan and whose plan has been declared successful, and his successful plan has been filed before the adjudicating authority, cannot at any stage, even before his approval, withdraw the plan. So that is one finding which we have seen from the court. The second finding is that once the plan has been approved, it is binding on all the parties, and he is duty bound to implement the plan. For this, we take the performance guarantee from him. That is called the performance guarantee at the time when his plan has been declared successful, which is quite a heavy amount. Now, if he doesn't implement the plan, he will be banned from bidding from any other plan. But yes, the question which remains is, what happens to the CD then? If you don't implement the plan, I think such cases are still to come up before the Honorable Court, that we have cases where they want to withdraw from the plan before the adjudicating authority approves it. But I have still to see court decisions where they are not implementing. See, in Mandana's case, we have this case, that Mandana Industries case, where the resolution plan is implemented. Resolution plan is declared successful, and Mandana Industries started implementing the plan, and they have withdrawn from the plan. Now, this case has gone back to the courts. There is no finality of what is going to happen. I am told that all the amounts which he has invested will get forfeited, this, etc., etc. But what actually happens going ahead to the CD is something which we still have to hear on this. So Mandana's industry case would be one of the first case on this point.
Thank you for giving more valuable insight into the case, Alokji. Next question is whether forensic audit is compulsory under IB code, and who will appoint the forensic auditor? Is it the responsibility of RP or CoC?
See, RP is only responsible for doing a transactional audit studies. Now, as far as section 66 is concerned of the IBC, it talks about fraudulent transactions. Now, fraudulent transactions falls in the domain of forensic audit. So, a transaction auditor and a forensic auditor, or only a forensic or any auditor who will also undertake forensic audit and transaction audits would suffice. So generally what is happening in all cases is we appoint a transactional auditor who does all the transactions during the 2 years period or 1 year period which has been prescribed for that PUFT transactions. That is the preferential, undervalued, and the fraudulent transactions. So these transactions, so we may not call it a forensic audit, but these are called transactional auditor. But to that extent, it is the responsibility of the RP. Even if you don't appoint a transactional auditor, you are supposed to detect it. He is only assisting you. The prime responsibility is of the RP to detect all these transactions. If RP cannot detect himself because of the work, he can appoint some auditor or accounting firm or a professional to detect these transactions and give it to him. But the word forensic audit has not been used under IBC, I may just say.
Yeah. So means the RP's responsibility is to report transactions under section 43, 45, 50 and 66. Correct, sir?
Yes.
So how to, okay, now I would like to give my personal case. The company was small and the financial creditor was only a bank. They said that okay, we have spent more money and now we don't want to spend good money after bad money. So, it was pertinent important for me to perform my duty as RP to conduct transaction audit. I did it myself and filed application also.
Yes,
and
Dilip bhai, this is the right thing, right approach which you have taken because it is your responsibility.
My responsibility. So whether the creditor want to spend money or not, it was my duty which I have to do.
Correct. So you have performed. Yeah, you have done your duty. And but that brings, see, if you don't get support of CoC in paying the cost of the transaction auditor, this is very means it puts a lot of pressure on the RP, like you have done. It can put unnecessary pressure on him and his team to do the audit, which is he's already burdened with a running company. So why put him on all these pressures? So that's the right approach actually. That's the law, if you ask.
Okay, and I would like to one more draw attention to the members who are listening. Friends, banks are appointing, there is a body called IBA who empanels forensic auditor, and banks are appointing forensic auditors or transaction auditor based on the list prescribed on the IBA website. I would like to draw your attention, please, for appointing transaction audit under IBC code. You need not be registered with IBA. You can be appointed as transaction auditor if you can give your quotes and to the RP who is conducting the resolution process, CRP process or liquidator.
Very right.
Okay, thank you. Now there are some questions are there. I think we have 5 or 6 questions. We will finish it up. Now, who should comply with the statutory compliance of the city, like filing of annual accounts with ROC in CPE period? I think you have replied this thing. During the process, we have to comply with this. Now, second question is about Seven Hill judgment and deals with leasehold property. Can we refer this? I think already you have discussed this Seven Hill question.
Yes.
If you want to, it pertains to what you call this thing. In Seven Hill question thing, leasehold property was not leased to the Seven Hill Hospital. Say property was belonging to MCGM Corporation, Municipal Corporation Greater Mumbai, and it was given on lease to Seven Hill Hospital. And during the concession agreement, it was said that the Seven Hill Hospital can raise loan. But once the project is complete, that is hospital is operationalized, they should execute the lease agreement. They were not able to complete the hospital project and they never executed the lease deed. On that premises, the property was taken back by the municipal corporation, sir. Alokji, do you want to add anything on this?
No, it is. As I said, that all the properties on which factories are standing in MIDCs and GIDCs, these are all leased properties.
Correct.
So those land is a valuable land. It has a lot of value, and there is a transfer fees to be paid by any purchaser of the property or when the shareholding changes more than 50%. So it is not that you cannot deal with those property per se. It is my understanding of the judgment that the interest of the leaseholder has to be taken into account at the time of the CIR. That is what the underlining of the judgment is. It is not that the hospital is standing, it has to be demolished and the land will be taken away, or the factory or the factory which is standing on GIDC land or the MIDC land, the factory can be dealt with and the building can be dealt with, but not the land. No, the leasehold land is part of the CD. It can be dealt with, but the interest of the leaseholder will have to be taken into account. And he should be part of the entire CIRP process.
Very true, sir. Very true. Now I'm going to next question. It is about home buyers. Are home allottees are secured final creditors, and how are they to be dealt with in case of liquidation under Section 53?
See, one thing, they are financial creditors. That is no doubt about it. That has been now put into the Act following Supreme Court decisions. So they are financial creditors. Now, as far as whether they are secured financial creditors or unsecured financial creditors, now that issue is still, I think, in the courts. It is not decided. And it is not that they are secured creditors. They have an interest in the property. To that extent, they are secure. It's not that they don't have any interest in the property. But security interest, the word security interest, which has been defined in the IBC, my view is these home buyers in liquidation proceedings, they will be financial creditors, but they may not be secured financial.
Yes. Yes, yes. I agree with you, sir. I'm proceeding further. For
Yes.
real estate business model prima facie have substantial cash dealings. How do you deal with the leakage in revenue and appropriateness of books of account?
Yes, see, another issue which I would like to bring into attention. See, IBC is not about, or the resolution professional is not here to dig the grave and find out frauds or run after frauds. He is a process runner for resolution. There is a small role of transaction audit, which we have discussed, section 66 in particular, of fraudulent transaction done by promoters. That has to be looked into. We are not saying, but RP, that is a small part of the IBC process where the RP runs. Earlier it was felt that that would be a very, very big role. Now that role it is important role, but it is not the only role of the RP or the most important role. The most important role is to get the resolution of the PD and see to it that it runs as a going concern and the realization is done of the financial creditors to the maximum. This is the main role. There is an important role of detecting the fraud of the promoters or any frauds which have taken place in the company, and that has been done by the transaction audits, and that also has to be done, for which a separate application is to be filed. But that is only one part of the law. So IBC is not about chasing promoters' fraud. Let's understand that.
Thank you, sir. Properly answered, sir. Now I am going another question. It pertains to capital gains in resolution plan. Whether capital gain tax will be applicable in a transfer and how will be paid after the handover the company to RA?
Another good question. I don't have 100% answer on it. I'm also in two minds in this answer question. Now see, if you see S. Kumar's judgment of NCLAT, if you read the judgment, what does the judgment say? It talks about case under liquidation. And this question is also liquidation. I have sold a property under liquidation and I have earned capital gains. Now what S. Kumar judgment says is that no returns are to be filed, no TDS has to be deducted from the of that 1% or 0.5%, whatever has to be deducted by the payer who buys the property. So no TDS returns have to be filed. So if I have not to file any return, I have not to make the P&L account, profit and loss account, file income tax return, not file tax return, not claim refund. So in that case, I have no responsibilities under the Income Tax Act. So what is my responsibility for paying TDS or paying capital gains tax? And in any case, courts held that the claim, if the government has any claim on capital gains, he'll be relegated down. A crown debt will be relegated down to category 5, which will be after all those given under 53. So supposing I sell the property today and I don't pay capital gains or I don't pay TDS, even if there is a claim, that claim will be below financial creditors' claim. So this is another argument which is taking place, that I'm not supposed to deduct one thing, and even if I'm a defaulter, so that claim of the income tax department will be, for non-payment of the capital gains, will be much lower. But see, I'll tell you, this is the evolving field. I am not convinced about it. I am telling you on this forum that on this issue of non-payment of GST and income tax by the liquidator, I am still not convinced that he has not to pay anything. As I am doing some work as a liquidator, I am making sure that I am paying the taxes and complying with the law, because I feel that this law has to, it is not that this law is not to be observed by the liquidator. This is what I'm trying to say. And the last word is not said on this issue. What is your view, Mr. Dilip Bhai, on this?
What you say is correct. Law is evolving, and second thing, the judgment was going to one point further. Okay, the buyer has to deduct 1% TDS. That TDS also is not to be deducted. Forget about capital gain subsequently.
Yes. I think the law is still not settled on this point, I must say.
Correct. Absolutely correct. Now, I think this is the last question, and it pertains to FEMA. Again, we slightly earlier you had given a hint that FEMA was compliant, and that question was not in detail, but now it is on detail. FEMA regulation, while giving out guarantee, falls under ODI regulations and can be given only after ODI regulation. So, was this considered, as recently NCLT held, that any deposit held by CD in contravention of deposit regulation would not be entitled to FCOC?
As I told you, in this case, I don't want to get into the nitty-gritty of Aditya Estates on this issue, but I can tell you that in Aditya Estates, finally we have received the approval for remittance to of this amount to ICICI Bank UK PLC.
So it implies that you complied with the provisions.
Yeah, means whatever RBI process was there was probably done, and the remittance was allowed to be made.
Thanks, Alok ji. I think any no questions are there any questions further? No.
Yeah, one or two are there, but I think we have already done a good amount of questions. If Alok ji is okay, maybe one or two, or how do you suggest, sir?
I'll take one more. No problem.
Okay.
Last question.
Okay.
Yeah, Dilip sir, please take. Yeah.
Now, last question, I would ask you this thing, that there is a dissenting financial creditor in this whole resolution process.
Yes.
So, was he able to receive the money received by the ascending financial creditor, or something less, something more?
Another important question, it goes a little deeper, which is not in public domain. So,
I'm not asking you what you call question. This is amount. I'm
yeah.
just asking.
See, I'll tell you, in this case, that something is not in public domain is that this dissenting creditor was not entitled to any money because of his dissent, and because the liquidation value, what happens is he is not entitled. He has only to get if the financial creditors, to the extent of liquidation, he is not entitled to any amount as per the IBC sections and the regulations. So he didn't get any amount, but he has a issue with us, which is still going in the court, which NCLT, which is not in public domain, so I would not like to discuss that issue today.
Right, sir. Okay. It replies to my this question, that whether equal, less, or more. So it replies the question properly, sir. Thank you. Thank you, sir, for giving us a vibrant and knowledgeable insight of the resolution process, in fact, and resolution plan. And in fact, you showed a beautiful bungalow also, and by breaching the confidentiality agreement. So we are also And on behalf of the Institute of Chartered Accountants of India, Committee on Insolvency, and all the participants, I give you heartiest vote of thanks to you. Thank you, sir, and request you to give us knowledge on the subject and enlighten the knowledge of the members regularly, sir.
Thank you very much, Dilip Bhai and everybody. Rita ji.
Yeah, sir, on behalf of the committee, we would like to thank to you as well as Dilip sir, for Alok sir for taking us through this presentation and giving us valuable insights based on your experience in conducting the CIRP for the case, and Dilip sir for moderating the question answer session by putting the questions as received from participants, the answers for which are good learning points. Thanks once again to both of you, sir, on behalf of the committee. Thank you.
Thank you.
Thank you, Alok. Thank you, Rita. Thank you, all members. Thank you.